Arbitration is the out-of-court resolution of a disagreement between two parties decided by an impartial third party known as the arbitrator. There's no judge or jury involved and no courtroom. It can be faster, less expensive, and a binding and final decision will be rendered. That's an excellent question. Ultimate decisions in arbitration are made by professional attorneys chosen by each side. These professionals are focused on the facts and the law and are not as emotional as a jury. Therefore, cases decided by arbitration become much less volatile and much more predictable. Punitive damages are awards that are intended to punish a defendant in cases like drunk driving. The likelihood and the amount of a punitive damage award in a long-term care case is significantly reduced in arbitration because arbitrators more closely follow the law as opposed to their biases against nursing homes, which many juries have. This significantly limits when punitive damages are appropriate. In addition, the existence of a valid and enforceable arbitration agreement dissuades lawyers from taking cases that are not meritorious. There are fewer frivolous cases in arbitration than in traditional court. Finally, reducing the amount of uncertainty in litigation allows a plaintiff and a defendant to narrow the range of outcomes, resulting in more quickly and more often reaching amicable resolution and settlement. Arbitration will be used in the event of a claim or a lawsuit. It would permit the facility and the other party to avail themselves of the arbitration procedure rather than to be forced to litigate in the courts and in front of a jury. An arbitration is much quicker than the traditional court system. Plaintiffs and the facility can resolve the dispute in far less time, which benefits both parties. Arbitration proceedings are confidential. The entire proceeding is conducted in private without personal, medical, and family information becoming public record. And arbitration is much more efficient and less expensive than traditional litigation, which results in significantly lower costs to all participants. Now, both parties benefit from the arbitration process. For instance, the risk of a runaway verdict or award is greatly reduced, which benefits both parties because those results often require appeal and result in the cases being sent back for trial again. That can delay resolution for years. A study by the American Arbitration Association indicates that an average arbitration takes about 7 months as compared to litigation, which on average takes 3 to 8 years, depending on the court schedule in various venues. Also, the scope of discovery is more limited in arbitration compared to typical court cases. Discovery means things like depositions of witnesses, production of records, and other potential evidence gathering. This will lower costs for both sides, and frivolous discovery can be avoided. Finally, arbitrations are less formal and less acrimonious than traditional litigation. The stresses on the parties is therefore lowered. To wrap it up, we highly recommend the use of arbitration agreements as part of a comprehensive risk management plan. HealthCap provides an arbitration toolkit available to all members online. Your legal and risk management team should consult those guidelines to consider how best to utilize arbitration for your specific organization.